this, but I think it's a good thing when you have on a 9-member Supreme Court people who don't always see things exactly alike and who do have different methods of interpretation and different approaches, because none of us have, well, you understand.
Well, the Chief Justice...
I can't even agree. I can't even agree with
You agree with that?
No, look, and I agree that you should have different people with different, who reach different results, but one would think that after 200 years, there would be some consensus on what we think we're doing when we interpret the Constitution. You know, I mean, these are wildly divergent views. Are we taking broad concepts such as equal protection and due process and asking, what should these concepts mean today? That's one view. Or on the other hand, are we saying, what did these concepts mean when they were adopted? Now, as for the difficulty of figuring that out, the historical problem, yes, there is. I'm not pretending that doing it by text and the original meaning of that text is perfect, that it's going to solve every problem. But it solves an awful lot of problems, especially the most controversial ones. It doesn't take a whole lot of history to figure out that nobody thought the Bill of Rights stopped a state from prohibiting abortion. Nobody thought that the Bill of Rights prohibited a state from criminalizing sodomy. Nobody thought that the Bill of Rights prohibited states from prohibiting assisted suicide. So many of the most controversial questions, it's a piece of cake to decide it. And it is not my burden to prove that originalism and this historical approach, what did the people do, what did they decide, it's not my burden to prove that it's perfect. It's just my burden to prove it's better than anything else. And the anything else is the other approach. It's up to the judges what equal protection should mean today, what due process should mean today. This is an immense amount of power in judges. And if you say that my approach should require historians, I cannot understand why your approach should require lawyers. I mean, what does a lawyer know about, whether there ought to be a right to an abortion or whether there ought to be a right to suicide? Let's put ethicists on the Supreme Court. Or what did I learn at Harvard Law School that gives me any capacity to decide these questions more properly than anybody else in the country?
You learned law. You learned law at Harvard Law School.
These aren't lawyers' questions. Once you reduce it to, what ought equal protection mean today? If you think that those words are empty bottles, let's be honest and say it's up to Congress to fill those empty bottles. That's the way the British do it. If they're empty bottles, and we're trying to figure out what does the current society think it ought to mean, whatever the Congress says, they know what the current society, I don't have any idea what the current society thinks. I don't want to know what the current society thinks.
Why should unelected judges be able to invalidate laws that don't conflict with the text of the Constitution?
Oh. Well, where is an example where they don't conflict with the text? I've never heard of somebody say not conflict with the text. The question is the word.
Try Roe versus Wade, just for starters.
Thank you. In any of the opinions, of course, you have words of the Constitution, like the 14th Amendment word liberty, or the First Amendment's word the freedom of speech, which don't explain themselves very often in difficult cases. So then I say life at the boundary is sometimes tough. It's like I keep thinking of the Frontier Patrol or something, because it doesn't explain itself. It's a hard question, and you have to have tools to answer it, and you put your mind to it. But the bottom line, if it's unconstitutional, is going to be that it's forbidden by this word or phrase or this part of the Constitution. And there's no doubt about that. And
it's easy to find those phrases: equal protection of the laws, due process of law. Those phrases are empty bottles if you accept the proposition that each generation can fill them up with whatever liquid it wishes. Now, I too believe in democracy, and I think the way it works is this: the majority rules. If you don't believe in that, you don't believe in democracy. Now, in a liberal democracy, which is what we have, there are some things on which the majority does not rule. That's what our Bill of Rights is about. The majority will not rule on religion. It will not rule on limiting political speech or any other speech, and so forth. Unreasonable searches and seizures, the whole list. That's mostly what the Bill of Rights is about. Limitations on the majority, which are applied through the judges. Okay. Who decided upon those limitations, however? The majority. It was the majority itself that imposed those limitations in adopting the Bill of Rights. And whenever the judges go beyond the meaning understood by the society that voted for those limitations, whenever it goes beyond that original meaning, it is in effect adding to those subjects that are driven off the democratic stage. Now, there was nobody who ever thought that due process of law meant that abortion could not be prohibited. It was prohibited for 200 years. Nobody thought it was unconstitutional. Again, I'm not talking about whether it's a good or bad idea. The question is, who decides?